objectives of My Vote Counts?
It's one of the objectives that My Vote Counts, but more importantly, it's one of the objectives of the legislation. However, it does not, the right, often what the Constitutional Court has held is that often undue influence can be exercised in various ways. And it doesn't have to be corruption directly as classically defined. And what My Vote Counts 2 says is that the public is entitled to know all of those donations, and the media and NGOs are entitled to know, so that they can interrogate and they can draw the links and they can expose what the underlying premise of a party's support base is and what really drives a party. So it doesn't have to be corruption in a true sense. It's anything undermining the right to vote, because the right to vote is the right to cast the vote, but it's the right to cast an informed vote, where you know exactly what the parties are about, what drives them, who supports them, how big their base is, where it's directed. So it's not only corruption, it's also the right to vote itself and right of access to information.
Isn't an informed right to vote also obtained from knowing what the party's policies are, knowing how they've performed if they're an existing party, if they're a new party, what the promise is, what the agenda is, what the mandate is, what policies they perform, what the values, what their vision is. Doesn't that all go to the body of an informed right? And not only who funds the party, that is but one aspect. And if the public does not know the full extent of who funds the party, does it detract from an informed vote when all the other issues are available as to what's our agenda, what's our policies, what's our values, what do we stand for, how we performed, how we voted on certain issues in Parliament? Isn't that more important to an informed vote?
Yes, Milady, this is an issue that the Constitutional Court actually expressly dealt with. And they said parties spend a lot of time on dispensing information to the electorate. That information is part. They say they spend sometimes over a year doing so. And those policies form part of what an informed voter would have. But what they also held is that is not enough. That's the express holding of the Constitutional Court, and I'll get to it, Milady, if you can. At the moment, I'm simply sketching out the matter. I'll get to the actual judgment, and all of this has been dealt with in the judgment. So, coming back, 15 million rand upper limit is, we say, is irrational. Also, has not been properly justified. It's excessive. It doesn't cater for related parties. It doesn't cater for different kinds of parties. So definitely for some of the parties, 15 million would be much more than their annual budget, and therefore can completely influence them, contrary to and sway the party into more corrupt domains. And it's not simply doesn't provide the guardrails that Section 19 and Section 7.2 of the Constitution require. And Section 7.2 has been interpreted, as I mentioned to the court at the outset, in Glenister and Helen Suzman Foundation, to require the state to take all possible measures to ensure that corruption is eradicated. The third tier, so first is the 100,000 rand threshold. The second is the 15 million rand upper limit. The third is expenditure, disclosure of expenditure. And my lord, my ladies, we have set out why expenditure is an integral part of the information that's required. Now, expenditure was not expressly the focus of My Vote Counts 2, although what My Vote Counts 2 says is relevant for whether there should be disclosure of expenditure. expenditure completes the picture in relation to a donation. So where you have a donation, let's say, 1 million or 2 million or 3 million, that is used for particular purposes. We know that there's public funding available, and we know that parties underuse or underutilize public funding. They rather prefer to use private funding, and they prefer to use private funding, it would seem, to cloak their activities. And what a voter is entitled to see is for what purposes is the 30 million contribution a year that's given by a particular donor to the DA or someone else used. Because that completes the picture as to why it's prized and why it's directed to that party. That is the picture, and they say, you know, the DA flippantly responds to it saying, oh, well, you know, they want to know whether we've purchased printers or whether we've purchased some other equipment. That is not, if that's all they've done, well, then that's great. That's the innocuous information that a voter is entitled to know that that's been used for. But it might have been used for other things. It might have been used for rallies somewhere or for other activities. We simply don't know. And that completes the picture. And we say that that forms part of what My Vote Counts 2, the holding in My Vote Counts 2, controls in this matter. And we'll take my lord and my ladies to those provisions. So that's our third pillar of our case. We then deal with the issue of the EMAA, the Amendment Act. The EMAA, which was passed and came into force in May 2024, just before the elections, and that legislation effectively changed the manner in which the disclosure threshold and the upper limit are determined. And it vested the power of determining those issues in the President. It also created a lacuna in the law. And My Vote Counts brought an interlocutory application or an interim relief application to ensure that in the interim, until this court has the opportunity to consider the merits of the matter, that there would be interim relief granted to ensure that there wouldn't be a lacuna. This was opposed by both the state and the DA. The judgment was granted in favor of My Vote Counts 2. First, a rule on my side was granted, and then the interim order in August 2024. And that effectively kept the old threshold and upper limits in place. But our challenge in respect of the EMAA principle is in relation to the President being given the discretion to determine the limits. Now, what's interesting is that in May 2024, immediately after Parliament had acted on the matter, they passed a resolution saying the President may determine the thresholds and the upper limit. And they didn't give him any guidelines whatsoever in doing so. That is how they understood the legislation, and they understood it correctly. They now try to row back from it, and they say, no, actually Parliament, the National Assembly must give detailed guidelines, and must actually determine the limit, and then the President must agree or disagree with it. Now, that is not what this legislation says. It's clear that the President has the discretion to determine the limit. That's what it says on its face, and you can't unread that. But even if they are right, that the National Assembly plays some role, the President should have no role to play in the determination of those limits. He is the political actor in charge of a political party. He is the worst position to make a determination of a limit and threshold which the Constitution demands. He is an inherently and institutionally biased person. Now, it's true, the respondents are correct, that he is not the only biased person, and it might be that the parties in Parliament also have interests, but at least it's a watered down, it's a first of all, a more open process, and secondly, it involves all the parties. Whereas here, it's a singular actor that's given that authority, and that simply doesn't control for the constitutional principles that My Vote Counts 2 has enunciated and have been enunciated in Glenister. It's simply not permissible for the President to be given that power to determine. And we make that forcefully. And the respondents say no, but Executive Council drew a distinction between Henry VIII clauses, where the President was allowed to legislate instead of the legislature, and everything else. And everything else you can just delegate en masse. That is not what Executive Council Western Cape held. It's not what subsequent case law of the Constitutional Court has held. Janssen van Rensburg, Darwood, Jassa, they all held that there are legitimate controls that you place on delegation. Because it is Parliament that's the lawmaker. It's not the President. The President is not the lawmaker. The President only gets into lawmaking pursuant to very specific subdelegation given by Parliament on issues where he's got specific expertise or it's practically essential for him to be involved. But in our case, where he is the one who's going to be either the beneficiary or the person at a disadvantage as a result of thresholds and upper limits, you simply can't give that power to him. It's not constitutionally permissible. It's not what the Executive Council of Western Cape allowed, and it cannot be suggested otherwise. That argument would cause a constitutional revolution if that argument succeeded. My Lord, my ladies, those are the key tenets of our case. Now, there are nuances, and I'll get to the nuances as we go through the key tenets, but I wanted to outline what our case was really about and what we base it on, and to debunk some of the major misdirections that the respondents tried to take the court on. So, if I may just start with the My Vote Counts 2 judgment, and I would like, if could I beg your leave, my Lord and my ladies, just to hand up copies. It is from our authorities bundles that were transmitted. My Lord, I apologize. Yes, it's the one. It's the bundle that was transmitted as the Lord presiding indicated on Friday.
I haven't seen before. Okay.
Yes.
This is not from you. This comes from the other side.
Yes. No, yes, they indicated in their email that they would have hard copies of their bundle on Monday. Our bundles are here too, but they are voluminous, and I don't want to. We'll leave them with the registrar, but I don't want to hand the whole bundle. At the moment, I'm referring to My Vote Counts too. If I may. Yes, my Lord.
In the venue. No, this was just placed here. I haven't seen this before. This was also just placed here on the bench. My files were all in another box or bag that I brought from home. I haven't seen blue files. When I noticed I got in this morning, there were no blue files. And I wasn't going to print somebody else's stuff at the public person's expense.
So this is
the 1216 of 1277.
This is 1216 of our bundle of authorities, my Lord.
Yeah, this is one of those that I saw on my cell phone on the weekend. But we were aware of the case.
Yes, of course, my Lord. Thank you very much. If I may take my Lord to page 1218 of that bundle. So I'd like to just contextualize what the Constitutional Court found and how strong and strident their holding was. Just to place all of that, place the rest of my submission on this. Paragraph 4, my Lord. Public and private sector corruption is a matter of great concern around the world, and it appears that the political landscape, and by extension governance, has not been left untouched. The need for efficiency and effectiveness in the prevention, containment, and elimination of corruption linked to private funding of political parties and independent candidates seem to cry out for urgent intervention. For corruption that follows from secret private funding could otherwise stealthily creep into our political and governance space, toxify it and fossilize it to our detriment, if it has not already done so. And then in 5, they say several issues thus arise for determination. And the first one and kernel of it, is the need to minimize the risk of voters putting into office or even electing into government a political party or independent candidate who is corrupt or somehow compromised. Right, my lord, if I may, my ladies, if I could take you to 1219, paragraph 23. So this deals, as I indicated to the court, this deals principally with disclosure issue, but it also talks to general principles to some extent. 23 says, and when access is sought to information in the possession of the state, then it must be readily availed. A challenge is, generally speaking, likely to arise when information is held by any other person. This is section 32 of the Constitution. There, information is accessible only when required. And required implies the need to demonstrate that there is a legitimate reason to grant access to that information. That ostensibly serves the purpose of ruling out unnecessary or spurious requests. For some information might indeed be such as to render it necessary for a requester to explain why it is really said to be required. That is an internal qualifier. Information will thus be accessible only if the requester is able to demonstrate that it is reasonably needed or required for the exercise or protection of any rights. So that centers the inquiry that was before My Vote Counts 2, and then My Vote Counts 2 held that it is required, that private funding information is required for the purposes of the right to vote. And I'll explain in the breadth of terms in which they held that it must be so. The 24, paragraph 24. When then is the reasonable or best form, what then, is the reasonable or best form in which certain information must be held? Should it be discretionary or obligatory that some or all information is held? How best should information be held to facilitate disclosure when required? For example, funding is generally given to a political party for the benefit of the collective membership, not an individual. Such information must be held or recorded. Similarly, the use of funding for independent candidates would ordinarily have to be accounted for. To do so requires record keeping and the preservation of that record. So they're building up, the court is building up to its main findings that everything, all information on private funding must be recorded, must be held, cannot be unheld, cannot be destroyed, and then must be made reasonably accessible. Then paragraph 25. I'm only reading the key things that I want to highlight to the court. I'm not, that's why I'm skipping certain sentences. It shouldn't be taken as anything other than just presentation of key aspects. 25, broadly speaking, the nature, importance and purpose of certain constitutional rights or information that relates to them could necessitate that information be kept and recorded for the sake of, amongst other things, transparency and accountability. Right, so that's the inquiry. It set the inquiry. It says you need to prove that you need the information for purposes of exercising rights. You've identified the right to vote and right to cast an informed vote. And what the court is analyzing is, does that encompass this type of information? And it goes through the exercise of that reason. And then it says in 27, and this is important, now it starts to analyze the actual right. And it sets out the right, and in 27 it says, the section highlights the right of every citizen has to make political choices. Choice is of its own a loaded concept, and much more is required of a choice maker if the choice to be made is political in character and affects important national interests. The gravity of the choice is more pronounced in relation to the right of an adult citizen to participate or vote in the elections for any legislative body. This is because of the centrality of elections in the functioning preservation and effectiveness of our constitutional democracy. So what they were saying is that the right to vote and the right to make an informed vote is absolutely fundamental to the democracy. And therefore, information, when later on in the judgment they say that information must be made available, they do so in that context. And the Chief Justice goes on to say, to recruit members or supporters, and it's the next paragraph, to recruit members or supporters and campaign for a political party or political cause, information would be needed. To be able to distinguish one party or cause from others would likewise require access to information about them. One also needs to know more about one's competitors to be able to appreciate their strengths, expose their weaknesses or wrongdoing, and magnify one's strength and make an informed comparison between her presumably more progressive policies and objectives and theirs. And what the court was saying is that those are critical constitutional objectives. And once you are dealing with the right to vote, you're not dealing with a private space. So it's not a question of making a donation to some sort of a bowling club that you have. It's making a donation to a political party that is contesting elections at the highest level, and those parties make decisions of the highest importance in the country. Therefore, they are held to different standards, and those that donate to them are in the public domain. They are not in their private sphere. So these arguments relating to, we must keep the secrecy and private because of the privacy interest, well, that has been argued and decided by the Constitutional Court. And the Constitutional Court has said that those privacy interests are worth nothing in the context of disclosure of funding of political parties. That is what that's what the effect of the Constitutional Court's, this argument was run fully. This argument was made by the DA. They ran it in this court, in My Vote Counts too. They didn't succeed before Mia J. They ran it on the papers before the Constitutional Court and then decided to withdraw their opposition to the confirmation. This is all old news. The privacy interests are all old news. It's been decided. Paragraph 30, over the page, 1220, my lord and ladies. The issues before us must thus be addressed as they ought to apply to political parties and independent candidates for any constitutionally recognized legislative body. After all, the need for recordal and disclosure of information ought to be fundamentally the same for all political parties and independent candidates, regardless of whether or not they are registered or seek to hold public office at a local, provincial, or national level. And the parties in this matter have all grounded their contention on the Constitution. It is to those constitutional provisions that they now address. Then they say in 31, towards the end of paragraph 31, they say regular elections, accountability, responsiveness, openness, and public office bearers who are committed to the core values and principles of good governance laid down in section 195 of the Constitution are what would facilitate the attainment of the South Africa we all deserve. So, my lord and my ladies, what the court was saying is that we need office bearers who are true to their oath, and one way of doing that, of ensuring that, is to have access to all information in relation to their funding. And they carry on. But this is also important, this dictum that I've just read is also important for the purposes of our upper limit case, because it is that kind of accountability and responsiveness and openness that's promoted by a restriction in relation to the upper limit. And the Parliament has clearly not done its job in that regard, because it simply imposed a limit that far outpaces any other jurisdiction, even that they've cited. We have other jurisdictions, and I'm going to talk a little bit about that fool's errand that the executive and the DA engage in by giving you very, very cherry-picked examples of certain jurisdictions. But I'm just, at this stage, just placing the principle that is not, our Constitutional Court has pronounced on the centrality of elections and the fact that it's a constitutional right. So you can't just borrow from other countries and say, well, they've, for whatever reasons, they've determined those as the limits, upper limits, or they've determined that is the threshold. It's just not a useful exercise. It's not a useful exercise because it has to be done in the South African context, both legal and socio-economic context. 32, paragraph 32. The right to vote derives its fundamentality from the central role voting plays in the establishment, functionality, and vibrancy of a constitutional democracy. It is a prerequisite for the very existence of the legislature and the executive at all levels of the state. And the proper exercise of that right is so critical to the coming into being of our political arms of state and the effective and efficient functioning of the entire state machinery that the need for transparency and accountability from those seeking public office is self-evidently more pronounced. The future of the nation largely stands or falls on how elections are conducted, who gets elected, how and why they get voted in. Only when transparency and accountability occupy center stage before, during, and after elections may hope for a better tomorrow be realistically entertained. This is not just a linguistic flourish. This is the encapsulation of the centrality of the right to vote and the right to make an informed vote. The Constitutional Court has... Yes?
Just, even if we accept all of these arguments, isn't the issue that this application is premature? Those limits have been are now obsolete. There is pending before the court, obviously Judge Jalari's order is in place, pending earlier this outcome of this application or the decision in Parliament and President. But that is now pending, so those limits haven't been set. Once they have been set, so that's separate from your primary argument on whether there should be a limit in the first place. But your second argument, which would apply to the threshold as well, those limits haven't been set. So how are we to determine something where there is a process in place in terms of existing legislation, that process must be seen through? And if, this argument has been raised in the heads, if you're not happy with the outcome of that or the limits as determined, then take those. But my concern is that we, as my sisters pointed out, there is a real separation of powers issue in that regard.
Yes, Milady.
Can I just add on to this? It's also not totally correct that in the deliberations nothing was considered about limits. Because there was a presentation in November or December of 2023, and there was a person commissioned, a certain Dr. Badenhorst, that made certain inputs to the committee. They dealt with and referred to earlier to Italy and Uruguay, etc. And those were there. I didn't want to interrupt you, but on that score, those are issues that will be considered by the committee in due course, now in the new process. And I'm sure that, as in the past, your client will make the
Yes. My Lord, if I may make submissions in relation to that aspect. If we just take, I just want to sketch out the chronology. My Vote Counts 2 judgment was handed down in June 2018. Pursuant to that judgment, the legislature engaged in drafting PPFA. PPFA became an act but wasn't brought into force until 2021. It became an act in 2019. It was brought into force in 2021. In 2021, the 100,000 Rand and the 15 million Rand limits were set. The thresholds and the limits were set. That is what we are challenging. In relation, there was nothing prior to that. So all of the presentations, my Lord is quite correct. There were presentations made after the fact in relation to any new limits that might be determined. That is a separate issue, and that's not connected with the challenge directly. And if I may just address the mootness point or right, I'm never sure whether it's mootness or rightness in this particular context, because we have, it could be one of both. The Parliament, the chronology is that 8th of May 2024 was the date on which the EMAA came into force. On that date, we say a lacuna has been created, and that was our case before Tulare J, and he granted an interim order to deal with it. So currently, pursuant to that interim order to preserve the status quo, those limits are in fact in place. That's the first issue. That's not a complete answer to Milady's question. I'm just sketching out the entirety of it. The second issue is that the EMAA, we say, is unconstitutional. The provisions that made a change to the 100,000 Rand limit, the disclosure, so sections 8 and sections 9 of the Act are unconstitutional for the reasons I've alluded to, but I'll go into in more depth. The President should have no involvement in the determination of those amounts, and the provision is unclear and contrary to Darwood and Janssen van Rensburg, and it's contrary to JASA. And we'll make our full, we've already set out the case obviously in our heads, but we will make fuller submissions to this court in due course on that score. So once those provisions go of the EMAA, then it is back to the PPFA as it stood before amendment, because those would be in accordance with the doctrine of constitutional invalidity. It's fully retrospective. The court simply declares conduct to be unlawful. It doesn't. It's unlawful ex tunc, unlawful from the date that it's been promulgated, and therefore EMAA provisions that we are dealing with would be impugned and would be taken back to what they were under the original PPFA. But so that's the second issue, and on that score there would be no mootness or rightness argument of any sort, because we would be back to the 2018 version of the Act. The third, or 2019 version of the Act. The third issue is that the new Act, as amended, so EMAA amended certain portions, but it didn't amend portions, for instance, that don't deal with related parties. It didn't amend portions whereby the threshold, first of all, exists. So the threshold does exist, and we say it shouldn't exist. But secondly, the threshold also doesn't differentiate between different tiers of government and between donor and donee. It doesn't do any of that work. So the threshold will again be a number. And that number is simply not constitutionally acceptable. It's not it's not in accordance with my vote counts too. So even if EMAA survives the Executive Council attack in relation to unlawful delegation, it doesn't survive the attack on its core tenets. And therefore, the mootness argument simply doesn't arise. The legislation is bad in amended and unamended form. And we'll argue that, and I'll take Milady and my Lord through the legislation to show why that is so. So if I may continue with the exercise in relation to my vote counts too, because it is really important to appreciate how broad the ruling is. The ruling is not simply, it wasn't giving discretion to Parliament. It was saying, Parliament, you failed to do your job as the Constitution requires you to do. You are part of the state, and you are required to take the legislative measures to bring to bear all reasonably possible force to ensure that disclosure takes place. So we were in paragraph 33, my Lord Milady's. This case is, after all, about establishing a principle-based system that will objectively facilitate the meaningful exercise of the right to vote, regard being had to its veritable significance, which he's just outlined. The court has just outlined the veritable significance, and then he goes on. The system's inbuilt capacity to sift the corrupt from the ethically upright is an indispensable requirement. Indispensable. For this reason, any information that completes the picture, and this is Milady's question also in relation to what is actually needed for a voter. Any information that completes the picture of a political party or an independent candidate in relation to who they really are or could be influenced by, in what way and to what extent, is essential for the proper exercise of the voter's will, in which our government is constitutionally required to be based. An environment must thus be created for the public to know more than what is said in manifestos or during campaign trails. As will become apparent below, what is implicitly envisaged in Section 19 is an informed exercise of the right to vote. So the court has dealt with the issue and has said, it's very interesting what you have to say, ostensibly. You are saying you are whiter than the driven snow. We want to see whether that's the case. And the voters are entitled to all information that about private funding for that purpose. That's what the court subsequently held. Then 34, for every citizen to be truly free to make a political choice, including which party to join and which not to vote for, or which political cause to campaign for or support, access to relevant or empowering information must be facilitated. Not only must the information be held in one form or another, it must also be reasonably accessible to potential voters. They needed to be able to make a quality decision to vote for a particular political party or independent candidate. And then the next paragraph is also partly important. For there is a vital connection between a proper exercise of the right to vote and the right of access to information. The former is not to be exercised blindly or without proper reflection. And then former Chief Justice's dictum is cited in support of that. Then paragraph 36 says public office is so important that it is only to be ascended to by those who have been properly examined and found worthy to represent the electorate. And that may only be so with the benefit of information. Without it, the ability of citizens to make responsible political decisions and meaningfully participate meaningfully is undermined. 37, this is the crux, the reason why I'm going paragraph by paragraph. This is the crux of my vote counts to finding. And it is an extremely powerful statement of the centrality of the right to vote, the importance of the right to get all information, and the fact that that information must be in totality collected, secured, and disseminated. 37. By its very nature, the proper exercise of the right to vote is largely dependent on information. No wonder it takes months, and at times even a year or more, for political parties and independent candidates to wage a campaign for public office. This entails imparting whatever information they consider necessary for the electorate to know more about them. That information sharing process takes the form of many house-to-house visits, town hall and stadium meetings, radio and television interviews, and newspaper articles. Billboards and advertisements are routinely used. There's a wide coverage of electoral campaigns on all media platforms. Then 38. That information is generally calculated to have the voters believe that the candidate it relates to can be trusted and deserves their support, because she's best placed to serve citizens in the public office being campaigned for. It seeks to demonstrate their abhorrence. So the parties seek to demonstrate that they have an abhorrence of corruption and all facets of unethical conduct. It is also meant to assure the public of their commitment to our constitutional values and to good governance. The centrality of the information to this process cannot be overemphasized. And then, this is some of the crux. This then means that political parties and independent candidates should not be left to pick and choose what information would be held, preserved and disclosed to those who depend on information, to determine to whom to entrust their future, that of the nation and posterity. All information necessary to enlighten the electorate about the capabilities and dependability or otherwise of those seeking public office must not only be compulsorily captured and preserved, but also made reasonably accessible.
So isn't that the key issue? It's necessary to enlighten the electorate. So how can a 50 rand donation from an individual be necessary to enlighten, so that limits the ambit of protection of the right? And how can that be reasonably necessary? Particularly in light of the purpose is to avoid corruption.
Yes, Milady, the court goes on to make pronouncements in relation to the totality of the information, and I have read paragraph 75 also, where they made it clear that what they meant is that everything needs to be recorded and held, and cannot be unheld, and what the only possible exceptions where the state might be able to justify is if it's trifling, negligible amounts, is what they have stated. Like a maybe a 20 Rand donation, I think is what they've cited as an example, or someone volunteering to do some work for the party. Now, that is not, first of all, it's for the state to justify it. It's not for us to justify that, because the principle is full disclosure as a general proposition. But secondly, that is not what's happening here. 100,000 Rand threshold is simply not, we are not talking 50 Rand donation. And the 100,000 Rand threshold is without control for related parties at all. And it's without control in relation to the tier of candidature. So the people at local government level who are independent candidates, for whom 90,000 Rand could be the entirety of their basket of funding, are treated in the same way as a party of Democratic Alliance's size, which has, according to it, hundreds of millions of Rand worth of expenditure. Well, you know, this legislation is fundamentally irrational. There's just no, you can't, it's irrational even if we didn't have my vote counts tools. If we just were relying on the irrationality like a new National Party case. But we have my vote counts too, we have the right to vote, and the standard is one of proportionality. The standard is not one of rationality when it applies to the state in this case. So, Milady, that would be my response on that score. Paragraph 40. The reality is that private funders do not just thoughtlessly throw their resources around. They do so for a reason, and quite strategically. Some pour in their resources because the policies of a particular party or independent candidate resonate with their world outlook or ideology. Others do so hoping to influence the policy direction of those they support to advance personal or sectional interests. Money is the tool they use to secure special favors or selfishly manipulate those who are required to serve and treat all citizens equally. And this is where we say it's the central. This speaks to the centrality of that information, but it also speaks to the centrality of information about expenditure. Because expenditure, how the political parties use the funding that they get, is a critical element to understanding the full chain of fund flow and why the donors might be interested in donating to a particular party. And then the court says unchecked or secret private funding. So not only does the court deal yes.
Yes, then on 11:37, let's take a 10-minute break. I also want to check. It seems to me the aircon's warming up instead of cooling us down. So let's take a 10-minute break. Let's say it's 11:40 and 15 minutes. 11:50. We'll be back again. So that everybody.
Yeah, this is good. When we come back, I'll ask you. Where should we get our input? Well, there's a couple of things. We can have lunch. If we order in advance. Yeah.